A very warm welcome. It's wonderful to see you here for our Global Environmental Law lecture series, even though it is at the end of term. And I would like to welcome Justice Brian Preston, who is also a visiting professor at Durham Law School here today. I'm absolutely delighted to have him here, and also his wife, Dr. Justice Preston, who came with him. They're both staying with us at Durham at the moment, which is a fantastic opportunity to get more involved with Justice Preston. He has already delivered a lecture seminar in the climate law and policy class, and the students absolutely loved it. They said afterwards, this is really rounding up the entire course also. So it was very much appreciated. And as many of you already know, Justice Preston is the Chief Judge of the Land and Environment Court in New South Wales. He's also a visiting professor at the Centre for Sustainable Development, Law and Policy, and he's delivered some incredibly important judgments that have stopped coal mines in New South Wales from going ahead, as you know. And today we are going to explore more about this harmonizing function of global environmental law. So how does global law, global environmental law affect implementation at the national level and thereby lead to harmonization effect, perhaps even. So I'm delighted to have you here with us today. Thank you very much for agreeing to give another lecture. And the floor is yours.
Thank you.
Thank you.
Sure, somewhere on the screen here. There we go. Okay. So it's a great honor to be able to deliver a lecture in this judicial lecture series on global environmental law organized by Durham Law School and the Centre for Sustainability, Law and Policy. The topic of my lecture is the globalization and harmonization of environmental law. It's a huge topic, and the PowerPoint presentation I prepared will take longer than the time available. So address key aspects in the PowerPoint presentation, but I'm happy for people to have access to that PowerPoint if they would like to have further information. The three parts to my lecture. The first, I'll deal with the globalization of environmental law. That's the spread of environmental law. The second part will deal with the harmonization of environmental law, how although it's spread, it's now becoming more consistent. And the third part, I'll look at the crystal ball to say, where do I think environmental law is heading? So the first part, globalization of environmental law. So what we see with the globalization is that there's been an increase in the number, the scope, the content, and application of environmental laws, and an expansion in the number, role, and influence of international institutions that are focused on environmental law. Let me expand on that. We can see this increase in four areas. First, the number of multilateral environmental agreements. Second, in the number of countries that are participating in those MEAs. Thirdly, the increased coverage of environmental issues. And fourthly, the increased impact of international law on domestic relations. I'll unpack each of those. The first is when we look at international environmental treaties, they were sectoral based. I'm not going to go through each of these, but they were very particular. What we then saw was, especially from the Stockholm Conference, but then I would say 1992, the Rio Conference, we started to see a great increase in the number of MEAs. And I've set out on the screen those that you can see, which followed the Stockholm Conference. There was a flurry of them in the 70s, and then we started to see some more in the 80s. But then once we got into the 90s, we started to see a lot more conventions. The next increase has been in the number of countries. And so whilst the number of countries in the world, of course, has increased, but we're also seeing an increased participation in MEAs. And that's a product of the increased awareness of environmental issues and the use of consensus negotiating procedures. What I think is the most interesting aspect is this increased coverage of environmental issues. As I said, originally, they were very sectoral based. Now what we're seeing is cross-sectoral issues, but we're also moving from the particular to the general. We're moving up to an overarching level of policy. And there also is a much more interdisciplinary approach. And so we see MEAs addressing the problems of the past, such as the triple planetary crises of climate change, pollution, and biodiversity loss. But we also see MEAs trying to head off the problems of the future by promoting conservation and sustainable use of natural resources. And the ambit of international environmental law is expanding, and we can just look at some of these topics: pollution of all types, biodiversity, environmental justice would be some that we can see. There's also increased use of framework treaties rather than specific ones. So the UN Framework Convention on Climate Change will be a good example. And then under those framework conventions, protocols are agreed. The Kyoto Protocol and the Paris Agreement would be examples. And that allows greater dynamism, and so that these MEAs can have the framework in the treaty or the convention itself, but in these protocols, which can be treaties themselves, they will be able to evolve. Otherwise, you have to go back and renegotiate the whole treaty, which is a difficult process. So it allows much more flexibility by using these annexes, schedules, appendices, or protocols under the framework treaties. The other important aspect, I think, in the change has been the increased use of the regular meeting of the parties, referred to as the Conference of the Parties. Before, it was rather formulaic. Now, a lot of the work is being done in the Conference of the Parties. And we see this particularly under the Framework Convention on Climate Change, where not only has there been, as I said, the Kyoto Protocol, the Paris Agreement agreed, but also the working out of the treaty is done through the resolutions of the Conference of the Parties. And those resolutions can themselves have legal effect. And so we're seeing this sort of tiering of from the Framework Convention to protocols and treaties made under that convention, and then they've got the resolutions of the Conference of the Parties. Now, that's all the upside of it. What's the downside to this increasing breadth of international environmental law and the number of countries that are participating? Well, in order to get consensus, you have to go to, in a sense, the lowest common denominator. You have to start using rather vague and general terms. If you've ever seen the treaty negotiations, you see all the words in square brackets, all the options, and it's all about trying to find consensus as to what words can be used and said that somebody won't object to. But it does end up with rather anodyne and vague terms in the treaty, and that can be a problem. And I give an example here about how you can have sort of multiple, definitions in relation to forest, for example. But that also leads, having this such vague language in the treaties can lead to difficulties when the matters go before international courts, because they say, what does it all mean? and they can get different of approach. And also, as I'm going to come to, where that's been incorporated, those terms in international treaties have been incorporated into domestic law, then the same ambiguity gets put into domestic law. And so domestic courts have the same problem of trying to interpret what it means. My fourth aspect on this globalization of international environmental law is the increased impact on domestic relations. So although international environmental law, in a sense by definition, has focused on interstate, that is between countries, relations, it's having a growing impact on the domestic relations of nation states. And increasingly, we're seeing international environmental law providing mechanisms for supervising the domestic implementation of or compliance with those international treaties. So the first example I give is the global stocktake mechanism under the Paris Agreement. And so, as Professor Minnerop has said, that contains element of a top-down oversight mechanism. Right, so a country has to put forward its nationally determined contribution, what it's going to do to reduce greenhouse gas emissions in its jurisdiction. And there is no direct enforcement mechanism in the treaty, but through mechanisms such as the global stocktake, then they will be finding out how each nation state is complying with its NDC, or whether the NDC is in fact ambitious enough or needs to be ratcheted up further. The Biodiversity Convention is another example where the parties are required to develop national strategy plans or programs for the conservation or sustainable use of biological diversity within their jurisdiction. So this is not like CITES, where you've got biodiversity that travels across borders. This is within the jurisdiction, and there is an obligation on the nation state to develop these strategy plans and programs for the conservation, sustainable use of biological diversity within their jurisdiction. So that was my first topic, where I've been looking at globalization of environmental law at the international level. I now want to look at the domestic level. So what we're seeing is an increase in the number, scope, and content of domestic environmental laws. So in the 1960s, there were quite few environmental laws in most countries. That's exploded. So 70s started to get a bit more, mainly pollution statutes, 80s even more so, but then from the 90s onwards, we're seeing an increase in the number and the breadth of coverage of domestic environmental laws. Now, that generates a demand for new or adapted environmental agencies to enforce these new laws. And also, it generates a demand for courts and tribunals with specialist environmental expertise and jurisdiction to uphold and enforce the laws. So we see in the domestic sphere both the increase in the laws, the increase in the institutions, and increase in the sort of judicial institutions to enforce those laws. My third aspect of globalization environmental law is in relation to global institutions. And so what I see is not only those institutions that are established under international law, the particular conventions, for example, which establish institutions, but we also see international institutions that are responsible for administering those MEAs and regional bodies. But we also see transnational corporations or industry associations and development banks that have a role to play in the upholding and enforcement of international law and practice. And I give the example of the World Bank and the Asian Development Bank. But we're also seeing non-state actors in the form of environmental NGOs. So famous ones that we know about, the IUCN, WWF, Earth Justice and Greenpeace play an important role in developing environmental law and governance, as well as both internationally and domestically. The IUCN, for example, has been influential in writing reports showing how domestic law can be, or domestic law and governance can be changed to implement international environmental law. And we also see non-state actors playing a role in addressing climate change. That can be through subnational governments, linking to carbon trading schemes, or cities that are setting common emission reduction targets, or businesses that are taking individual collective action, or investors that are disclosing the carbon footprint of their portfolios. So you can see there's been an increase there. I'll give you some statistics. As at mid-2022, 29,000 non-state actors had listed climate actions on the UN Global Climate Action Portal. So it's a much more diverse range of actors than we think. We're also seeing bodies that are responsible for adjudicating international environmental disputes. So there's been a number of bodies set up since the establishment of the ICJ, although it has to be said the number of bodies with competence to deal with environmental matters is still limited, and I've listed some on the slide. That's all I wish to say about my first part of the lecture, the globalisation of international environmental law. Let's come to the harmonisation. So how can we achieve harmony? Well, I suggest there are three ways. The first is international law influencing domestic law. The second is the reverse, domestic law influencing international law. And the third is horizontally the sharing and adoption of domestic laws between countries throughout the world. Start with the first, the influence of international law and domestic law. Now, to be effective, international law must be implemented domestically. We've seen that, for example, I showed you the Biodiversity Convention, which said the nation states have to implement laws, policies, programs at the domestic level to protect biodiversity. So we can look at, in the domestic context, the three arms of government: the executive, the legislature, and the judiciary. And I'll just quickly show how it is that international law can be implemented by each of those arms of government at a domestic level. So starting with the executive. So the executive government can implement at a domestic level international law in three ways. First, by entering into international agreements, that's a decision of the executive government. Secondly, integrating international law into domestic decision-making, particularly through policy. And thirdly, enforcing domestic, international, and domestic laws. I'll deal with that each. So firstly, the executive can enter into international agreements that are relevant to environmental protection. And we've seen that increasingly done. My earlier point is we've seen an increase in the number of countries that are now signatories to international environmental agreements. The second way is by integrating environmental law into domestic decision-making. So if we go to one of the documents that was agreed at the Rio Summit in 1992, which was the Agenda 21, that emphasizes the importance of integrating environmental concerns and responsibilities into domestic decision-making. I've earlier referred to the Biodiversity Convention, which requires the implementation in domestic decision-making. But there's another way in which we can do it, and that is by integrating the norms and the rules that are part of international law into domestic law. And that can be done by adopting national strategies. An example is from Agenda 21 to adopt strategies for sustainable development. And Australia did that in 1992, immediately after the Rio summit in 1992. But it's not only the executive that can do it. Sometimes we can have courts or tribunals that are exercising executive functions through merits review of executive government decisions. And they too can integrate international environmental law and principles in their decision making. And I've given some examples of that. One is a decision, or a couple of decisions in the New South Wales Land Environment Court, and another was a decision of the Queensland Land Court where that's been done. But the executive can also incorporate the international agreements into their domestic policies. I'm going to come later to how the legislature can incorporate in legislation. But at this point, I'm just dealing with the executive incorporating international law through policy. And an example is in my home state of New South Wales in Australia, where that government adopted a climate change policy framework, which says expressly that the New South Wales government endorses the Paris Agreement and will take action that's consistent with the level of effort to achieve Australia's commitments to the Paris Agreement. It also endorsed the temperature and time targets of the Paris Agreement, and so that there would be New South Wales is aiming to achieve net zero emissions by 2050. Now, that policy incorporation of international law has legal effect. Although policy and law are different, by incorporating international law into policy, there still can be a legal effect. I give 5 ways here. I'm not going to go into too much details. I just want to give you the headlines to show you how the incorporation of international law into policy can have legal consequence. So I give 5 ways. The first is that the incorporation of international law into policy can create a relevant consideration that an administrative decision maker is bound at law to take into account. And I give some examples here of cases around the world where domestic courts have held that the international law or the incorporation of the international law into domestic policy does have legal consequence, in that it becomes a relevant consideration that the decision maker is bound in law to take into account. So one case is the Earthlife case in South Africa. A second case is the Court of Appeal decision in the Heathrow third runway decision, although that was subsequently overturned by the Supreme Court. A third example is a New South Wales one, where there had been a domestic policy which what I really referred to about the climate change policy framework, which adopted the Paris Agreement, and that became, the courts held that that was a relevant consideration to take into account in decision making. And then I give another example of a decision that I made in Gloucester Resources. It was a merits review appeal from a government decision to refuse an open cut coal mine, but I took into account not only that state policy that I've earlier referred to, but also Australia's national policies, together with the adopted or endorsed international agreements, including the Paris Agreement. And the final example I give is a recent decision of the Queensland Land Court in Waratah Coal, where the court, again exercising a form of merits review about a decision to whether to approve or not a coal mine, took into account the Paris Agreement and the carbon budget that can be developed in order to understand the temperature and time targets under the Paris Agreement. My second way in which there can be legal consequence for the executive government incorporating in policy a international environmental law is that step of incorporating it into policy can be reviewable by the courts. So the very action of setting the policy has legal consequence. And I give the example of the Thompson case in New Zealand. There also can be a consequence, a legal consequence, if the policy that's adopted is inconsistent with the primary legislation, and so that the policy itself becomes unlawful. And the two examples I give, one is in the Friends of the Irish Environment case, where the Irish Supreme Court held that the policy was fell short of the sort of specificity that the Irish climate legislation required. And the other example is a case brought by Friends of the Earth in the UK, where the UK High Court found that the net zero strategy, a form of policy that was required to be adopted under the relevant climate legislation in the UK, was also inconsistent with certain of the statutory provisions. But what if they adopt the policy which incorporates international law in some way, but don't implement it? That too can have legal consequences. And the example I give is the Lagari case in Pakistan. There, the Pakistan government had adopted two national policies to deal with climate change adaptation, but they didn't implement them. The failure to implement those policies had legal consequence because it led to a breach of human rights. And the Lahore High Court found that there was that breach and ordered the government to remedy that breach by implementing the policies. There can also be an adoption of a policy, but when they implement it, it leads to some breach of some other law. And the case I give as an example is the agenda litigation in the Netherlands. There, the Supreme Court of the Netherlands upheld the Court of Appeal's decision that the Netherlands climate policy failed to meet two of the articles under the European Convention on Human Rights. My third way is that it can have legal, move to a different point about implementation by the executive. So this one is that the nation state, the executive government of the nation state, can actually implement international environmental law. We think of the fact that international environmental law has to be implemented or at an international court. Not necessarily. It can be implemented at a domestic level, provided, of course, that the international law has been incorporated into domestic law. And so the example would be the CITES, the Convention against the International Trade on Endangered Species. There is an incorporation into domestic law. So there's the international trade in endangered species, but if there has been an infringement of the convention as incorporated domestically, domestic courts can enforce that breach. Let me turn now to the implementation by the legislature. So the legislature can promote harmony by ensuring that domestic law conforms to the nation state's obligation under international law. Now, different individual or different legal systems of countries will determine the manner in which international law can form part of the domestic legal system. So as we know, there's two basic legal systems, a monist or a dualist legal system. Under a monist legal system, international law becomes part of domestic law upon the nation state's entry into and ratification of the international treaties. But under a dualist legal system, notwithstanding the entry into and ratification of an international treaty, there still needs to be incorporation of the international law into domestic law. Now, that leads to a debate about the extent to which international law can become part of the domestic law in dualist legal systems. Now, certain international environmental laws require countries to incorporate the international rules and norms under those into domestic law. So I give the example of the Biodiversity Convention, which requires that, I'll call it, incorporation into domestic law. But even some soft law instruments purport to require the incorporation of incorporation into domestic law of international environmental principles. So the Rio Declaration, if you look at Principle 11, states that states shall enact effective environmental legislation, which give effect to the principles in the Rio Declaration. I earlier mentioned Agenda 21, which was agreed at the Rio Convention in Rio Conference in 1992, and I set out there a number of articles from Agenda 21, which requires effective legal and regulatory frameworks to be implemented. As I said, domestic legislative action is necessary where international law requires parties to perform a particular act within their domestic jurisdiction in order to implement the convention. And CITES would be an example that I've earlier referred to. The Paris Agreement has been incorporated into domestic law by increasingly number of domestic legislatures by either passing new legislation or amending existing legislation. And I've given some from my region, the Asia-Pacific region, Papua New Guinea, Fiji, and Australia. But also subnational legislatures, such as states or provinces of a federal system, can incorporate the Paris Agreement, and the state of Victoria has done that. That's the legislature. Now let's come to the judiciary. What can the judiciary do? Well, I suggest there are four ways in which the judiciary can implement international law. The first is by recognizing the rules of international law and incorporate them into domestic law. The second is by statutory interpretation to promote consistency and harmony. The third is by referring to international law as a source of guidance in the development of domestic law. And the fourth is implementing, developing and enforcing domestic environmental law that incorporates international law. So coming back to that first one, so recognizing rules of international law that incorporated in domestic law. So it means seeing to what extent we can those laws have been incorporated. So the first way could be by looking at customary international law. There are various ways in which domestic courts can see how customary international law has been recognized domestically. That has led to some commentators suggesting that certain principles of international environmental law may have reached the status of customary international law, and hence will be incorporated into domestic law. Just get that through that. That is not without contention. In Australia, there has been a robust debate about the extent to which international environmental law may have been incorporated into domestic law. I give one example there of the Ministry of Immigration, Ethnic Affairs and TIO, where it was held that an unincorporated convention on the rights of the child could be relied upon as a limitation of the exercise of ministerial discretion. However, in a subsequent case, that was doubted. Nevertheless, this principle seems to have been accepted, that where a statute or subordinate legislation is ambiguous, the courts should favour that construction which accords with Australia's obligation under a treaty or international convention to which Australia is a party. Which leads me to my second way, about statutory interpretation to promote consistency and harmony. Now, a number of statutory interpretation principles have been developed to assist courts to determine the influence of international law and domestic law. But the first is, where legislation is intended to give effect to international agreements, weight is to be given to the construction that the international community would attribute to the instrument or concept. So we'll come to, under the Vienna Convention, sort of certain interpretive rules, but what they're saying is, how would the international community look at the international law, and then domestically, the courts would adopt the same approach. Second principle, where legislative provisions adopt the words of a treaty, those provisions should be interpreted using the interpretive principles applied to the treaty, such as Articles 31 and 32 of the Vienna Convention. The third is, a generally accepted common law principle of interpretation is that domestic legislation is presumed to be and is construed by domestic courts to be consistent with international law. And so international law can become an indirect source of domestic law through the use of international law by the courts to interpret the statutes, develop the common law, and particularly in the area of administrative law. Now, the international law can also be a source of guidance in the development of domestic law. So courts in Australia have referred to international law in the development of the common law, Australia being a common law country, where the common law is uncertain or ambiguous. And I referred there to one of the cases I mentioned, that TIO's case, where it was said that a ratified but non-incorporated treaty can still be used as a legitimate guide in developing the common law. And the fourth way that the international law can be implemented is by the judiciary, is in implementing, developing and enforcing domestic environmental law. As I said, domestic courts can implement and enforce domestic environmental law that does incorporate international environmental law. And they can also flesh out and build upon international legal principles to make them work at a national level. And we've seen that with some of the principles of sustainable development, particularly the precautionary principle. So I give some examples there of decisions in New South Wales and in Victoria, and also in Queensland. And coming back to the climate law, the Paris Agreement can influence domestic courts' applications of its norms in domestic law and decision-making. And that is so regardless of whether there's been a direct incorporation of the Paris Agreement into legislation. And so that was done both in New South Wales and in Queensland in the cases to which I've earlier referred. So that was the big one of the influence of international law on domestic law. Let's look at the other way around, the influence of domestic law and international law. And there we can see there's 5 ways in which there's been an influence. So firstly, at any meeting of the international community, such as the Conference of the Parties, state representatives will bring their domestic perspectives to bear in discussing international issues and events. So something like the precautionary principle is quite interesting. The German representatives, at North Sea negotiations and conventions and meetings of the parties, brought their notion of the precautionary principle, which then starts to be incorporated into international law. Secondly, concepts and principles of domestic law can be used by the country's representatives in negotiating international law. I've given that example about the precautionary principle and how that then flowed through. Thirdly, the experience of countries in implementing international environmental law at a domestic level will inform the development of later international law. Now, I've quickly skated through the development of international environmental law. I said there's a move towards framework conventions. There's a move to having flexibility by using annexes and protocols, schedules. That's coming from the difficulties in implementing earlier treaties. And so there's a feedback loop. And so that there's an evolution in international environmental law from the experience on the ground of countries trying to implement it. And fourthly, when parties, when participating in meetings of the parties or conferences of the parties, countries use their experience in implementing environmental law at a domestic level to formulate resolutions at the conferences of the parties. So the very conference of party resolutions are informed by parties' experience in implementing it domestically. And the fifth way is that domestic environmental law can influence the decisions of international courts and tribunals. So if you look at, for example, the ICJ's decisions, especially in more recent times, they are looking back at domestic law courts' decisions. So something like, Christopher Weeramantri's, discussion of sustainable development and looking at whether it's part of customary international law, he looked at domestic jurisdictions, particularly in the Indian subcontinent, to see what is the content of international law. I come to my final section. So I've had globalisation, harmonisation. I now want to look at the influence between domestic law and state. So this is a horizontal influence. So we can see this sharing and cross-fertilisation at each level, the legislature, executive and judiciary. Legislature, one nation state looks to another nation state to see what domestic legislation they have implemented. Executives, the executive governments look to what other executive governments are doing. What policies are they developing? What know-how strategies are they implementing? And they share that. Judiciaries, what we're seeing is transboundary judicial dialogue. You've only got to look at cases such as the Urgenda case or other cases. Some of my decisions you can see that we're each referring to decisions in other jurisdictions. They are not binding, of course, they're not precedent because they're in different jurisdictions. But insofar as there is an approach, a reasoning which is applicable, that can be invoked by other judiciaries. So I give you an example of the two of my decisions in Telstra and Gloucester, where I drew upon, and I've set out the courts there from New Zealand, India, UK, US, Pakistan, Netherlands, just to give some example of where I was looking to get assistance in deciding under domestic law. And similarly, in that recent decision at Waratah Coal, the Queensland Land Court drew upon other jurisprudence in other countries. Another illustration we can see is in the public trust doctrine, and where although it starts in Roman law, moves into the common law, and then moves into various constitutions and statutes around the world, we see the sharing of knowledge about the meaning and application of the public trust doctrine. I'll give another decision, just a recent one of mine, where I drew upon that jurisprudence from around the world, from the US and from India and Hong Kong, about what the public trust doctrine means and its application to a particular asset of the public trust, which was harbours. We also can see this cross-fertilisation between domestic courts through a capacity building programs for judiciary. So the UNEP has been involved in this, as the Asian Development Bank. We see the sharing in information platforms such as Ecolex and Infomea. And the Global Judicial Institute on the Environment has also facilitated that judicial knowledge sharing between judges. And there has been bilateral and multilateral exchanges between judges of courts. So, for example, the Land Rover Court in New South Wales and the Supreme Court of Thailand have had a twinning relationship, which has been facilitated by various international NGOs. And there has been international programs for improving court performance, which is shared. You also can see some non-government and private initiatives which leads to harmonisation. So this can be at the by way of environmental standards. So we can think of the equator principles for banks. We can see in relation to the task force and climate-related financial disclosures. And we can see other organisations and principles, such as the principles and climate obligations of enterprises, which I put to the right-hand side there, the book, and you can look on the website about that. My final topic, and we'll wrap it up, is future directions. Where do I think we are moving? Well, first, I think this globalisation and harmonisation will be facilitated by at least 3 initiatives. The first is, I think there'll be a need for more effective global environmental institutions for improved governance. So the problem with, we've still got a plethora of international institutions. They don't coordinate with one another, and there needs to be better cooperation between those, but they also need to have more teeth in what they can do. So I think that there will be that push to try to get more effective institutions. In relation to courts, one of the problems, of course, about international environmental law has been enforcement. As I earlier showed you, there's a number of bodies, but each has limited jurisdiction. So that has led to a push for an international court for the environment. That hasn't yet happened, but we're seeing that push, and that has also been pushed at a regional level, so that there may be a sort of a regional court for the environment, which nation states can participate, much like the Caribbean, Court of Justice, for example, where the Caribbean nations have agreed that that can be done at that level. My second prediction is that there'll be a need for greater cooperation to reduce the overlap in the content and scope of MEAs and to improve the coordination of the activities of international organisations. As I said, there has been a dramatic increase in the number of MEAs, which has led to, in effect, treaty congestion. And that means there's so much work to be done in trying to implement them. There needs to be that coordination. And that may well be that we can clean out some of those. we're getting these overarching framework ones like the Climate Change Convention, or the Biodiversity Convention, but could we not incorporate in a sort of super Biodiversity Convention CITES and the regional, migratory animals and birds treaties and all of those things? They could be incorporated and we get some streamlining and synergies. And my third prediction is that there will be an increasing synthesis between international environmental law and other areas of international law. So one area we're seeing this intersection is with human rights. And so increasingly, we're going to start seeing, rather than having the siloed approach to human rights and environmental law, we'll see an integration. We can also see that, particularly through the climate change lens, with refugee laws, or what it means at international law to be a refugee. Can you have a climate change refugee? Trying to get the intersection of sort of refugee law and climate law at an international level. So I've given this back to the human rights. We can see that there is this intersection between human rights and environmental law being recognized at the international level. So the UN Human Rights Council resolution recognized a human right to a safe, clean, healthy and sustainable environment. And then last year, the UN General Assembly recognized the human right to a clean, healthy and sustainable environment. I mentioned the refugee law, and so there we can see that I think there will be a recognition of the interactions between, for example, climate change events and people who are disrupted and displaced by those events. My conclusion. So as the global character of environmental problems becomes more apparent, we can see that the laws, at both domestic and international laws, are responding. International environmental law has evolved over, since I say 1972, into a sophisticated conglomerate of laws, principles, and institutions that is increasingly becoming intertwined with domestic law. The growth of international environmental law and its incorporation into domestic law has resulted in this globalization and harmonization of environmental law. International institutions have facilitated this process by driving the development of environmental policies and spreading common standards throughout the world. And I predict this process will continue as the international community considers new approaches to tackling environmental problems. So thank you very much.